we have with us now
Tom Fitton. Tom, it's Judge Richard Weinberg. Welcome to the show. Tom Fitton is one of the leading advocates for open government, for uncovering the truth. Judicial Watch has had litigation where they've revealed the cover-ups and the deep state. You're to be commended for that. I'll tell you, Tom, what I'm very concerned about now is the attempt by the media and by officials who should know better, the President of the United States, the Vice President, the Speaker of the House, the majority of the Senate, trying to intimidate the justices of the Supreme Court on this absolute theft of governmental property, this abuse of the judicial process. What say you, Tom?
I think it's a dangerous time for our rule of law in our republic. The left has now decided that all bets are off when it comes to the deliberations of our judiciary and the Supreme Court, and they're to be pressured the way any other politician would be pressured. And it's a dangerous game in the sense that the leak of this draft opinion is putting the lives of the justices at risk, because you could have some lunatic decide that the way to protect Roe versus Wade is to kill one of them.
Yeah, I think
that is such an outrage that has happened.
They're giving out their home. They're giving out their home addresses.
They're giving out their home addresses, Tom, and they're organizing demonstrations and walk-bys their homes. I mean, this is absolutely awful.
It is, and every judge in the country must be looking at this, thinking, "There, for the grace of God, go I." Because this hasn't only ruined the Supreme Court and damaged the Supreme Court, but every appellate court and, frankly, every judge who engages in confidential deliberations must be thinking, if I have a hot case that there's public interest in, am I going to be able to decide this case without leaks or pressure like this? This is awful. And the Supreme Court specifically was damaged. And the question is the damage reparable and how extensive? But these are dangerous times. If I were the chief judge and the chief justice, and I ain't no lawyer, but I know enough about the law that the court has inherent authority to institute contempt proceedings and to initiate its own investigation beyond having the marshal do it, I'd bring in a prosecutor. I'd bring in a special counsel to figure out what went on here.
Well, that's exactly it. I don't know if the Chief Justice has that authority, but certainly Merrick Garland, Judge Garland, the Attorney General of the United States, can do that. That's what they should be doing. And the President, the Vice President, the Speaker, and the majority of the Senate should be quiet on this issue. If I was going to give my advice to the Supreme Court, I would issue that. I'd have a meeting tomorrow, take the vote, and issue the decision, and close this down now. What say you?
Yeah, I think I guess this is a tactical and strategic debate that they're having right now, because any difference between the decision or the draft opinion and the final opinion is going to be scrutinized and frankly, the final opinion is going to be undermined. Now, I'm sure the opinions changed since it was initially drafted in February, but thinking about your idea, and I think it's important because the justices' lives are at risk here. They should just revert back to the first draft and release it as the opinion of the court, with the justices who want to sign on to it, presuming there's a majority.
But how can they release it when there were no arguments presented before the court?
No,
it's like rendering a verdict about a trial, and there was no trial.
No, I think there was an argument on this. Wasn't there an argument on this, Tom?
There was no argument because it's a draft opinion.
The opinion was written after that.
No, I think there were arguments last year, Governor, and I think
there were arguments last year, but they were not the arguments that the court was going to rule on. They were arguments, but the court is ruling on the arguments that come before them. This is part of our process itself, and then the court hears the arguments and goes back and makes a decision. If the decision could become
Governor, they had the process happened. The process went through. The typical Supreme Court decision-making process was proceeding. There was a draft that was created after the court met, after they had their oral argument on this debate, and Alito was tasked with drafting.
Yeah, I think that's exactly right, Governor. I think they had oral argument on this.
Yeah, right, but even though he's drafted an opinion, the other judges haven't heard it and they haven't discussed it.
Yeah, there was something I read today, Governor. It said the court has confirmed the authenticity of the draft opinion, but stressed that it is not final and did not reflect the final position of any member of the court in the statement.
That's exactly what I'm saying.
So it's
Right,
premature.
right. No,
It's really
I
premature.
think the governor's right in that regard, and that's why it's a question. You know, is this draft opinion even going to get a majority? What would get a majority at this point? And, you know, now we've factor of the public disclosure of the initial draft. What a mess. What a mess.
It is a mess. Well, Tom Fitton, thank you for your input, and we'd love to have you on again soon. And we're hoping for America and praying for America. Thank you so much.
Thank you. Appreciate it.